guardian ad litem office in Milwaukee County. I've been wonderfully privileged to volunteer there for about a year and a half now. I also just work with Legal Action of Wisconsin in their eviction project, which is different from this. But in that connection, again, it's been a great opportunity to see a part of the litigation work. This is civil work, not criminal work, to which I was never exposed before. And so it is a part of the world that I did not have any previous engagement with. I knew that it was out there, but it's been great. Not fun. This is not fun litigation, but certainly interesting and engaging. And so, very, very generally, the very brief tutorial on this is two kinds of major cases. One are situations where children identified as being in need of services, children in need of protective services, CHIPS cases, you've heard those. And those are situations where, again, initiated by the state, by the district attorney, there's an identification, could be from all sorts of different sources, could be at the time of birth, could be a neighbor identifying a young person in a neighboring home who needs some assistance. Could be at school, could be an after-school program, or something about a youth's presentation suggests that they're not getting the medical treatment, basic familial support, education, food, all those kinds of things. And typically then, a variety of statutes in the state of Wisconsin, the state of Wisconsin, through the DA's office, will initiate a petition called the Children in Need of Protective Services, alleging the various things that are problematic. And again, the goal there, depending upon what happens, is ultimately to reunite the family and to bring the parents back in touch with their young people. But immediately, and actually tomorrow morning, reminds me, I'm on intake duty, which means that these are all the cases that have been coming in probably right now during the day and tonight. We're quite literally identified at 10 o'clock tonight. What do we do with these children right now? So that's the intake tomorrow morning. And again, premised upon some probable cause to believe that the children are not being well cared for. There's some initial decisions made, including foster placement tomorrow morning by noontime. What kinds of things should the county be doing? Should other private social service agencies be doing? All that is put together as that is litigated down the road. The other kind, of course, is I shouldn't say more serious, but it's often the second portion of these cases, and these are the so-called TPR cases, termination of parental rights. And there's a situation where, okay, we've tried to reunite the young person with their parent, and that has not been successful. It's clear that the parent is not engaging in the protective services and other things that we've offered to them. We need to terminate the rights. So you think about that. I often speak about imprisonment being the most significant thing that a government can do to you, and I think that's right. But boy, think about terminating parental rights, literally taking your children away from you and saying legally for the rest of that young person's life and your life as well as a parent, you are to have no more legal involvement at all. Wow. And again, it happens all the time. I've had a number of trials, almost always those cases will go to trial. And again, it's a matter of presenting through witnesses who come in and testify about what did and did not happen, describing not only what the parents have done, what they haven't done, and arguing, again, on behalf of, as a guardian ad litem, the role that we play is not to be the prosecutor, but do things in the best interest of the child. And so quite literally, my clients, the clients of my colleagues, they call them wards, and I get used to that, and judges would say, Mr. Santelle, you're a ward. And I would think, oh, they have a ward now, right? It sounds very Dickensian, doesn't it?
Yes, it does.
So that's the way of describing it. But our purpose is not always united with the state, because there's sometimes we think, well, wait a minute, maybe there is something more that we can do on behalf of this child that does not involve terminating parental rights or doing some other things. The best, and so quite literally, the client is the child for us. Thus the guardian ad litem in litigation for doing all these cases. The TPR cases, as these all are at the height of human tragedy, right? Because there are situations where opportunities have been given, not taken advantage of, and now we're going to do or attempt to do this dramatic thing. And almost always our position is that, yes, Judge, we think you should terminate the rights of this parent. It took me a while to get my head around that. That is a very stunning thing to say in a court of law, and again, it's a part of work. So in any event, this has been a great education for me as well, not only procedurally, it is not at all intuitive. In many ways, I say this is like the tax code, all sorts of processes and things inside the Wisconsin statutes that are not at all intuitive, so I've had to get to know that. But again, as a trial attorney, I can do a lot of that basic work when it comes to examining witnesses and doing evidence. One of the things that happens then, and this is quite literally what I shared with my friends, including Christensen and others, you may recall a couple of weeks ago, actually about 3 weeks ago now, this story that got a fair amount of news, continues to get a fair amount of news about the two young boys, a 7 and 8-year-old, who literally break out of the kind of the basement area of their house. They are found outside, virtually naked, and thus begins the story. Neighbors saying, I didn't even know that there were children there in the household. Again, most of this, I won't give you all the details because some of this is not in the public domain, but most of it is. Plainly, have not seen the light, quite literally the light of day for all of their lives. There's some truly profound developmental issues. Language, they do not have language at the age of 7 and 8. Bodily functions, and one of the boys is still wearing a diaper at the age of 7, right? Again, all this is out there in the public domain. So I'm not telling you, you can otherwise take an investment in as well. The house itself, just disastrous. It's almost like something put together by Hollywood, that this is the kind of thing you would put together if you wanted to, almost a horror movie inside. It had not been fed for days, no water, no drink, no schooling. The school had no record of them at all. The mother, again, in the public domain here, horrified, of course, when the two things happen. When, of course, the children are taken from her immediately to get them quite literally bathed, to feed them, to begin to work with them, to clean them up quite literally, and do those other things. She is, of course, charged right away by the DA in a criminal case, related but different from the guardian ad litem matters that we're working on. And so at the initial appearance, she appears, again, you probably saw this in the 10 o'clock news, in custody, and she is beside herself that her children are not with her. And her question to me was, the children were placed, frankly, out of the city for a while. Now they're back in this area as the foster parent situation got clearer. Her great concern was whether or not her boys were together. And I don't mean to make light of that at all. I understand that completely. On the other hand, you have to ask yourself, okay, if you've got this great concern about your boys being together, where was the concern to feed them, to bathe them, to educate them, to get them basic medical care? I've never been to a dentist, never been to a doctor before. And so this is a profoundly troubling case. I will tell you that I've got a docket right now, about 20 of these. They're all variations on those things. This is probably the most dramatic one. Certainly there's one that's out in the public for consumption. But the takeaway from all of this is, for me, and I suspect for you as well, that we, as much as our own families have our own challenges, undeniably in healthcare, education, all these kinds of things, and should be engaged and are engaged in all these significant issues. In our very community, we have young people and families generally. This is children's court, it's not family court. That's a little different jurisdiction. This is children's court. We've got children in our community who are living in these absolutely, positively meltdown, deplorable circumstances, and identified many times just by virtue of happenstance. And so the question is, what do we do as a community with them? Imperfect, always, and the great struggle during the course of litigation, whether it's a CHIPS case or a TPR, is what is the ultimate goal? How can we get the 4-month-old, the 4-year-old, the 14-year-old to a spot where she or he will have some developmental opportunities down the road? That in itself is not easy, right? And you've got obviously social workers involved, and caseworker managers involved, and the DAs involved, and we're involved. The judges plainly are the ones who make the ultimate decisions here. But it is at some level, and I don't mean to be cavalier about it, is intellectually fascinating, as you can well imagine, to think about these kinds of things and apply the law to it. It is also humanitarian based. It is horrifying and just stunning on a regular basis. That again, this is not in some foreign country somewhere. This is in Milwaukee, 5 and 6 and 10 and 12 miles from where we are right now. And where the children tonight who are being identified, who tomorrow morning will be on the docket, the intake docket for me, and then Monday will start again, and that sort of thing. So it's a great, again, I appreciate the opportunity to share it. It has been tremendously educational for me, moving for me on a regular basis, and a part of the life in which we live, all of us do, and a part of what we need to be committed to, right, going ahead, to work on that issue too. They're the next generation of voters and of people who are responsible, right? Got to get them to a spot where they are getting food and getting education. It's that basic. It's often quite striking. Yes, please.
How long are you involved with them?
So yeah, typically the cases do not last years, which is nice, unlike regular civil cases, including some things we'll talk about tonight. Criminal cases, likewise, much longer. If, for example, when we're to indict a president, sometimes those cases also go on for long periods of time, right? Typically, it is a matter of months. One of the great frustrations I have that I will tell you, having come to this from a system where we had a Speedy Trial Act, and the question always asked me was, Mr. Santelle, why aren't you done with this? When is discovery going to be done? A judge is always pushing appropriately, right, Barry, to have these cases resolved and get them done. One of the other frustrations that I just shake my head at all the time are the continued delays. Well, Judge, I did have an opportunity to talk to my client, the father. And well, okay, we'll put this over. I had a case just early this week. I'm ready to go, doing some substantive decision making. And because there's so many cases pending right here in Milwaukee County, which again, top level number of cases of the entire state, the judge said, all right, so we'll schedule this over. And I'm anticipating, okay, maybe early September. We've got something for you in late October, right? And so in the meantime, okay, the child is in foster care and other things, but that notion of we need to work on this and get this done quickly. There are some cases that are extraordinary that do last years or so. Some of these cases go up in appeal. Obviously, you've got the TPRs. You're taking my children away from me. They can appeal to the Court of Appeals here in Waukesha or in Milwaukee. In the case of the things of the Bell Phillips Center, that doesn't mean that the children are exposed during that period of time, but just that it's not resolved yet. Well, on appellate court, and because of that, the appeals court has an obligation to try to resolve cases on appeal within 30 days of their getting them. That's pretty good. Actually, you might think, gee, 30 days? For an appellate court, that's actually, I think there's a priority to do that. But it is not weeks, it is months. And I have a couple of cases still that were brought in on intake in late 2022. And here we are in August, and we're still getting delays. And again, I always walk out of my office and walk down the hallway and say, it's happened again. We just postpone these things, and everyone's happy to toll time limits, do those kinds of things. That's my frustration with the system. The people who are involved are, for the most part, not always, but for the most part, pretty much committed. The social workers, the case managers, the DAs are usually pretty good as well. Judges are good and attentive as well. So, and I would otherwise invite you to see this, but of course, unlike the cases that are in the public domain, these are not public proceedings because they involve juveniles. So I always refer to them as, this is the case involving best interests of JS, right, or that sort of thing, or SH, or that sort of thing, or KH. And so they're not in the public domain. And frankly, it's the kind of thing that if you could somehow strike that information, it would be fascinating and also educational for people in our community to see. And it'd be involved, at least watch a trial where that is part of the focus. So CHIPS cases, TPRs, and again, it has been good for me too, just to recognize once again what my own community is about and the challenges we all have.
But take care of your mental health, because that's got to be very
exactly. Yeah.
Well, that's what I was wondering about the mother too.
Yeah.
Is there some kind of mental health issue going on?
Absolutely, and so part of this too, it's the children, that's my focus, right? But there's also part of this that says, okay, is especially the CHIPS cases, right? What services are you going to provide that? And great number of situations where a mother, I hate to say it, but typically fathers are either not involved or absent or unknown, or there's a whole process for adjudicating, determining who the father actually is, that sort of thing. But part of the process is providing that for those mothers in the CHIPS cases with the services. I've got a very young mother. I was telling my friends here tonight about this, again, very generically, a young mother who's 19 years old who has 4 children, okay? And she just doesn't know how to parent, right? It's just basic, doesn't understand what a baby needs in terms of nutrition and care. And so trying to provide her with that service to get her to the educational level and the human level to understand that. But that's another part of these cases where they've got a father involved, you often have grandparents involved, and siblings who may also be out there, wherever they get involved here, right? So it is not easy, but again, intellectually fascinating, and good that our community, I'm not talking about me, but good that our community is trying to address that problem in a very imperfect way.
Thank you.
Good.
Yes.
Great. Thanks for the opportunity to chat about that. And so on that happy note, right, we'll chat about things that are very much in the public domain. And this is our fourth session. We plan, as always, to talk about executive branch issues tonight. And we will do just that. Believe it or not, the White House once looked sort of like that. You would walk up and down, I think that's on actually the south side of the White House when John Adams was there, or perhaps Thomas Jefferson, but no longer. But today, as I said, we're going to talk about executive issues. All of them, as you can well imagine, are much related to things we've chatted about before, which includes judicial issues and legislative issues. Can't separate them out. I'm going to tell you tonight, as we committed to do along the way at the start of this, also very topical. I'm talking about some specific news events. How much more topical can you get than this afternoon when I came home and wanted to refine this a bit, and sure enough, there was one more piece of news out there that we're going to chat about that also underscores that. So very topical, but also some good stories. Our principal focus tonight is going to be on the powers of the executive branch. What can executives, presidents, governors do and not do? What are the limits of that? And how is, again, of course, interpreted that and limited that? We're going to also get some civics tonight, thus the name of the course, right? Summers for Civics, about some theories about executive authority. We've already talked about one of them, is the major questions doctrine of a couple of weeks ago. I talked with you about another one that even predated that provides some basis for understanding how the courts and how our government generally has defined the powers and the limits of executive authority. As I often do, we begin not in America, but let's begin in Ecuador, of all places, right? And you may recall well that way back in May, a president named Guillermo Lasso, we will see his picture in just a moment or so, declared, with authority under an amended constitution, Ecuador dissolve the parliament. Now, you can say, well, gee, the parliamentary authorities do that all the time. They do, but it's always because they have lost the support of the community, they've lost the support of the parliament, the House of Lords, the House of Commons generally, and for that reason, need to reorganize government. Here what you have is a president, again, his name is Lasso, who also has his own great problems, which we'll see in just a moment. And he decided back in May simply to dissolve the parliament. He did that under a constitutional revision that was put in place in 2008. The idea was, well, there are times when in our nation's history, this is Ecuador, we have come to complete deadlock. We cannot resolve things. Imagine that, right? That you may have a legislature and a legislative branch that cannot come to grips with its duties and responsibilities. And so the idea was, okay, let's kind of do a reset. Is almost exactly how the Constitution is interpreted into English. The idea that we'll all go away, we'll calm down, and we'll come back and do some new elections, reconstitute, and see if we can finally get beyond what has been these great impasses. And so the concept again is not completely atypical in the world, but it is certainly it is atypical. It's not unique, but it's certainly unusual. And in May, Lasso, for the first time in Ecuadorian history, invoked that 2008 principle of the Constitution and said, all of you are going home. And we're going to have elections down the road, but in the interim, under the Constitution, this particular executive has complete plenary authority. And he has the authority to issue executive orders, which we'll talk about again tonight, and to do all those other things that a legislature would do. And the only requirement is that within about 10 to 20 days after he, in this case, declares that the National Assembly, is what they call it, is no longer going to meet, he's got an obligation then to set a time for an election. Can't simply dissolve it and not give you some sense of what's going to happen down the road. And he did that. You should know as well, if you go back and look at Ecuador, up until recent times, believe it or not, Ecuador, again, as you know, located kind of on the northwestern side of the South American peninsula, has enjoyed some great economic successes and has been actually a time after some periods in its past when many of the people are prosperous.
Most recently, however, under Mr. Lasso's administration and other times before him, a lot of that has been compromised. And so there's great concern about the violence in this country, economic bribery and fraud, those kinds of things. And so we've got a nation of 18 million people where there's undeniably turbulence. And so what happened, of course, is that, and there he is, that is the President Lasso, who has again made this decision and did make the decision back in May. And among other things, just as we had talked before about Benjamin Netanyahu, Mr. Lasso also has his own problems, because right before he dissolved the National Assembly was already pursuing an investigation on whether or not to impeach him. Why? Because there's the allegations that are also the subject of some criminal charges that, again, under their system may be percolating up again, some graft, some fraud involving, as you see there, a state-run shipping company, some paybacks, an oil tanker, and because of his involvement in that, there are an awful lot of people in the National Assembly who were perched on, who were going to vote to impeach him and then to try him, as we would also do in our system. Mr. Lasso, alleging that, again, the country needed a reset, instead decided to send them all home. And so that's what he did in May, and that's where we are. He's, as you can see, this is a private, sort of like blue sky, but it's in Ecuador. The director of Transparency International says, you know, this is not a good thing. Even in a transitory period where you've got to have a constitutional National Assembly at some point, it's still a bloated democracy. This notion that for any period of time, certainly beyond several hours, you've got an executive who's making all the decisions is problematic. The rule of law is not being advanced, and an awful lot of people looking to this in Ecuador right now is seeing a nation, an ally of ours once again, that is falling into not only disrepair, but arguably into turmoil. And speaking of, so what's happened is that he has in fact set an election. And that election is scheduled for, look at your calendars, August 20th, all right? That's 9 days from now, all right? And the reason why that's especially significant is because just yesterday, this happened.
Yeah.
And his name is Fernando Villavicencio. And again, he is among about 8 different candidates for the presidency and for this election coming up in August 20th. And he has gone down, and he is assassinated during the course of a political rally in which he is very critical of Lasso and the government and those kinds of things. There's another fellow who was a mayor back in July, same kind of thing. He is also assassinated in this nation. So this, again, you plenty saw the news about this last night. It's plainly a nation in turmoil, and it occurred to me again, not only because of the discussion we've often had about the rule of law, but this is also an example of what happens when you do not have a balance of power, right? The checks and balances. If in fact, and I'm not saying that the assassination here of these two, this individual in particular, is a direct result of that, but you plainly have a nation we have previously thought of as being a rule of law type nation that at least right now is not. We hold our breath to see what happens in the next 9 days and see what happens if indeed the election does not go as Mr. Lasso might want it to go. There are about, again, 8 different candidates. Mr. Villavicencio was one of them. And we will plainly continue to look at this not only to see what happens in Ecuador, but also as a rule of law discussion and a point of attention and focus. And then we have this in our nation, which you've also seen, and I do this specifically. I decided to juxtapose that with this. During the course of my term as a criminal prosecutor, there are various times when defendants obviously are indicted by a grand jury and then are told basically that they're not to have any involvement with witnesses and not to do any witness tampering, not to in any way affect the discovery, which is the evidence in the case, not to do things that obstruct justice along the way. That's a part of your basic instruction at the time of your initial appearance. Don't be out there doing anything that could compromise the proper and appropriately movement forward of the case that's against you, that will again assume that you are innocent until proven guilty. And when I looked, as all of you did, last Friday and saw that this presidential candidate published nationwide the statement, if you go after me, I'm coming after you. I could not help think again the juxtaposition with what was going on in Ecuador, of course, even more dramatically with things happening there. And I'm not saying that prompts an assassination here, but it certainly encourages the kind of violence that regrettably is in Ecuador as well, and other places around the world. It plainly also encourages those people out there who would say, you know what, if there are people out there who are going after candidate Trump, I need to support that as well. I will also say to you, again, just as a little bit of a matter of a process here, that if in the course of regular events, in a case that I would have prosecuted, not nearly this notorious or famous, I never did anything at this level, if a defendant had sent a letter to a witness, published something publicly, been out there in the news, said to someone else that if you come after me, I will come after you. The response in the federal district court in 14 miles from here in East District, Wisconsin would have been for the judge to say, Mr. Santelle, defense counsel, regardless of what we're doing, whether a civil trial, criminal trial, I want to see all of you, including the defendant, this afternoon at 2 o'clock. And we're going to get to the bottom of this, and we're going to ensure that this defendant understands what's going on. There would have been, it happened a few times, an immediate response to this kind of thing out there, and the judge would have called that defendant in, asked defense counsel, how do you explain the conduct of your client, who is plainly in violation of the very directives that I gave him at the time of the arraignment and plea? Explain this to me. And I did have more than a few occasions, inside those few occasions, where if the judge is not satisfied with the response, which difficult to be satisfied with any explanation for this, right? The judge has the capacity to detain and imprison that defendant. And it happened. Now you can purge yourself of that if you come to the judge and say, you know what, I explained something away. Give me something to justify, not justify, but perhaps put this into some context. You can purge yourself for that. Pre-trial detention is not a right. It is a expression of the largesse of the court. If you've been charged with an offense, yes, you're presumed innocent until proven guilty, but there's probable cause to believe that you've committed a crime. And we have detention hearings, we've got other proceedings where we talk about these kinds of things. And if you engage in this kind of behavior, where you're suggesting that indeed you're going to be going after witnesses and trying to go after the investigators and maybe the prosecutors as well, that will, in the normal course of a federal process, land you in the incarcerative clutches of the U.S. Marshal Service. And it is a concern to me, I will tell you, that in America, as we talk about somebody who could be our next executive once again, exercising all these kinds of powers, which we'll talk about tonight, that here, Judge Cutchin, who tomorrow afternoon will have a hearing on this, so you can watch the news tomorrow on this, has instead, she's very good, and I don't mean to be critical in this forum of her, but my experience was that judges would not solicit from me a memorandum of law on what to do about this, and solicit a brief from the defense about what this means, and then have a very civil proceeding tomorrow about what we're going to do about this. This would happen immediately, and there would be some immediate reaction to the federal district judge. Plainly, she's doing this because she knows that she is under the national scope here and is very much attentive to be as fair to him as possible. This is the kind of thing that, again, other things out there as well. This is the kind of thing that is undeniably an attack upon our basic processes. And if it is not stopped in some way, and if he is not told by she will tell us tomorrow, if there is more of this, at some point, this defendant, like any other defendant who would do this in America, needs to be in the incarcerative custody of the United States Marshal Service. And that could happen. That could happen. I suspect you, like me, believes that Donald Trump will not be quiet. And whatever the judge tells him tomorrow will not. But she needs to follow up on this as well. That's why I tell you that not only because in the judge positions we talk not about the executive, but also about how stunningly inappropriate and stunningly illegal. This could also form the basis for separate criminal charges returned by an indictment. Witness tampering, obstruction of justice. That's what this is. Only because he's got so many indictments out there, I suspect there is probably a disinclination to do this, but this is no small thing. And it's happening right in our nation as well. Susan.
Has
Tony,
Right.
the guy in Israel,
Absolutely.
all over, I mean,
South
all
America
these
is
old
right.
guys who just refuse to give it up.
It's about the way the power is lapsing, right? And so you reach out and you lash out, right? I think there's something to that. We haven't talked about Brazil and other venues out there as well. There's a pattern there, right? Right. And it was perhaps again at the end of the career. Yes, please.
It certainly won't stop as far as I'm concerned, I think, because he's going to claim being a victim and get more money and get more votes.
Right. And then, so
So
point,
he's gonna
right?
continue to do it, so
Right.
he'll end up in jail someday. for
And the
this.
concern, of course, is that
But that won't
if
stop.
yeah, please go ahead. Yeah. If the judge does at some point incarcerate him, could you imagine that headline? It would be more than, again, I find this hugely entertaining and humorous. That only USA Today, after all the things that have happened, can 2 days ago publish a big banner headline that says, "Trump in legal peril." Okay, in legal peril. Good. If he is incarcerated, can you imagine what the headline will be? But I think you're right. That will probably only encourage those people who think that he is a martyr, right? In fact, not understanding how violative of our fundamental system this kind of behavior can be, in addition to the things for which he is charged.
They just don't care. I mean, they're at this stage in their life, what have they got to lose,
Right. And three, and probably when we get together again, probably a fourth indictment coming out of Georgia next week, almost certainly, right? So to the extent that you have discussions with anyone, know that this is when I first saw this is beyond anything that's even in the arguable category of this is not First Amendment. It is not. And this is so far beyond anything that any defendant should be permitted to do that at some point, even for this, he should not only be sanctioned, but probably, again, should be incarcerated. He can purge himself of that, but again, the fact that you are on your release pending trial does not mean that the judge does not have the ability to put you in prison if you misbehave even during this time period.
Jim, Phil has a question.
Yes, I'm sorry, yes.
He can't get a get out of jail card free from the state charge, right?
Cannot. So well, unless of course there's state people who are engaged in fraud of some kind. But I think your question goes to the federal charges, which this one is. This is about January 6th. And this, of course, could be, depending on who the president is, we'll talk a little bit about that in just a few moments. The Constitution does vest in the president the capacity to grant pardons and reprieves, but those are only related, exactly right, to federal cases. And so the Fannie Willis, the Georgia matter that could be indicted next week, the New York matter involving the hush money to the porn star, that one also pending. Those are criminal matters, they're state matters. They cannot be the subject of a federal pardon, right? Nor can the Department of Justice, the federal Department of Justice, do anything to affect Fannie Willis, who is a part of the DA's office. She's an elected official there. Alvin Bragg in Manhattan, an elected official, part of the state system in New York, cannot direct those state prosecutors to do something that they would not otherwise want to do. Not to say, again, that there may be other things that could be addressed by defense counsel in those forums, but there are two different kinds of prosecutions and subject to entirely different kinds of possibilities, as you said, do they get out of jail free card.
Well, I'm just gonna ask about DeSantis dismissing two DAs down the floor. I mean, they're elected, how can you do that?
The answer is he can't, right? And so that is for consumption of the masses, who again, unlike you and the rest of us, don't have the fundamental understanding of civics, right? The governor of the state of Wisconsin does not have the capacity to terminate the employment of a district attorney, right? That cannot happen. Publicly elected, you can do things to recall that person, depending upon what role they're playing. You can impeach judges and justices, but another official does not have that capacity. I look at that too, and I think he knows better. He knows that that's not the case, but he's relying upon the notion that his constituents, and perhaps all of America, fundamentally, forgive me, are stupid. And that we really don't understand that he doesn't have that power to do that. And let him try, right? And let
He stepped down. I mean,
Right.
the guy in Hillsborough stepped down.
right, just because of the intimidation, right? And that's when I see that too, I think, I understand that, you're getting threats and you want to preserve your own life, you think this is something, I don't second guess that approach at all. On the other hand, the concern is that by doing that, you are sanctioning that behavior, right, from the government. And you're saying it'll be effective. And you don't have to get rid of me in a way that you can't exercise anyway, I'll simply leave, and he wins. It would be fascinating for any of those VAs who also find themselves on the receiving end of the governor's petitions or other things to pursue that in court. I would like to think that in Florida, the Supreme Court and lower courts would say, no, Mr. Governor, you do not have the authority, and those cases should be thrown out immediately. The authority simply doesn't exist. He's playing with Floridians as he has had in other areas, right?
One more.
Yes, please.
So, my understanding was that if you accept a pardon from whoever, that's like admitting guilt. Yes?
So I'll answer that very briefly. So if you keep your other thought, the answer is yes. There's a Supreme Court case that the name of it escapes me. I can provide it to you that address that very issue. If I accept a pardon, I'm acknowledging that the underlying offense conduct is that I did that, and I'm acknowledging that I'm guilty of that conduct. The only way that you can get a pardon, again, through the Department of Justice or even from the president directly, is acknowledging, implicitly if not explicitly, you did this. And that is a matter of Supreme Court law.
So, if you decide, for whatever reason, to pardon yourself, who knows? I mean, that just...
Right, and so one of the things, again, that is also fascinating about this man, the possibility that he would take the presidency again, very little doubt that if he does become our next president again, that all of these federal prosecutions, you can simply direct your attorney general to dismiss them all, and that could happen. We saw him beginning to do that under his own administration with Bill Barr, right? That could happen. The issue of whether or not you can pardon yourself, we'll take an indirect look at that in just a few moments. An awful lot of, myself included, you look at the rights established and authorities given to an executive authority, including our governor, they're not reflexive. The Constitution does not vest in you as the incumbent of the position some individual personal rights. They're things that go in the opposite direction, right? And so the entire concept is, I can pardon other people, I can grant reprieves to other people, and I can't pardon myself. The difficulty with that is, with appropriate respect, would he understand that? The answer is probably no. And the real problem with the pardon authority is it's unchecked. The Congress does not have to review pardons, and the Congress has no involvement. I suppose someone could bring a lawsuit. The question is, again, standing, how that would be resolved. Again, James Madison, how often we've said this, never contemplated this kind of thing, right? And that's the reason why it's so authoritative. So let's talk a little bit about what the Constitution does say about our president, and also perhaps even more questions about the capacity of an individual to serve in that role. The very first portion of Article 2 says, we're creating this thing called the presidency of the United States of America, never done before on the face of the planet. Executive power vested in a president, 1787, 1789. And here's the thing you should know, and again, it dovetails off of the questions you've already asked. What are the qualifications for serving as our president? There are 3 of them, and there are only 3 of them, okay? You know what they all are. You have to be born in the United States of America, okay? The initial language also says, well, because we're a new country, we'll give you some leeway. If you were born in Europe, all those people have died, so today, you have to be born in the United States of America. You have to be 35 years old, okay? And you have to have lived here for 14 years. That's it. Those are the only qualifications in the Constitution, okay? Your question, of course, is what about someone who is convicted of, or even alleged to have committed a federal or state crime? There is, as Kristen is appropriately shaking her head, there's no prohibition in the Constitution
Constitution, because once again, James Madison never envisioned that we would have a candidate who would be under this kind of peril. Nothing to prohibit a president who has been not only charged, but arguably convicted of state and federal crimes from serving in the office, at least under the Constitution. How that would work, if indeed that very same person is also incarcerated, I do not know. Again, the U.S. Marshals, I suspect, are meeting privately right now to ponder how that might look. But there's no prohibition on that. And so it's the other reason I will go down this rabbit hole a little bit further, that even with the pendency of and the scheduling of these trials now, in the January 6th case, just this afternoon, Jack Smith indicated he's looking for a January 6th trial day, January 2nd trial day. We will see, as I often say, whether that sticks. That strikes me as awfully soon for all the things that have to happen here. We know that in South Florida there's a May trial date. We'll see if that sticks as well, but let's assume that that goes ahead. And even if they do, even if those trials do go ahead, and there is a prosecution in a trial to let's assume there is a conviction, okay? What will happen, of course, after that is weeks after that, there will be a sentencing, and there may be post-trial motions filed. There can be appeals of these things, also to the courts of appeals, and it will be well into and beyond 2025 before any of these cases, now charged, will be completely resolved, okay? And that's the reason why, and Donald Trump appreciates this as well, that just in terms of timing, if indeed you are the president in early 2025, you can in fact shut all of these things down and basically not face any sort of consequences for that. All of it, again, you have to, the notion therefore that you're going to see any defendant, including a Donald Trump, in prison at any time in the next years, unless Judge Chuck and others do something in this other area, highly, highly, highly unlikely any of these cases will be brought to full fruition, as in final judgment, Supreme Court, other courts saying final judgment, and now it's time for you to go to prison. That will not happen in 2024 before the next president is sworn.
Or you owe us dinner.
I'm sorry, what?
I said, or you owe us dinner.
Or you owe dinner in New York City, exactly.
Yeah.
Exactly. So, again, significant to know that. Other parts of this, again, is not only about presidents in our nation, but also overseas. Same kinds of things are out there. Commander-in-Chief of the military, no small concern, right? Given some of the things that we're now learning about January 6th and attempts to arguably invoke the military to keep in power. You can also, interestingly, under our federal constitution, you can ask all of your agency heads, all your cabinet heads, to give you reports, or as the Constitution says, give me opinions on things that you're working on, right? And that basically means that the executive branch, again, is responsible for those agencies and those cabinet level offices that the Congress has created, right? You see that all the time. And here's the one we talked about already. We grant reprieves and pardons for offenses against the United States, and that's it. There is nothing about that whatsoever that says the Congress has to provide its advice and consent. Nothing about that that says the courts are involved in that in any way. That's the language, dead stop, period, on that. And then this is, again, one of my favorite portions of Section 2 of our Constitution, also referred to a lot during the Trump administration. The president has an obligation to take care that the laws be faithfully executed. Remember these conversations while Donald Trump was the president, in which an awful discussion about whether or not he was taking care to determine whether or not the laws are being faithfully executed? That's in the Constitution. And I've often thought that to the extent that there are proceedings to impeach a president, that's a basis for doing it right there. It is one of the last portions of Article 2 of the Constitution. And beyond that, of course, you've got all these other things that the president can do. Makes treaties, which is important for a news item we'll see in just a moment or so. Appoint ambassadors, public ministers, all those appointments, all of those by virtue of advice and consent of the Senate, Supreme Court justices, and lower judges as well. All those things come out of Article 2 of the United States Constitution. As you can well imagine, in the state of Wisconsin, we've got things very, very similar to this, but we've also seen in our state recently the use by this governor of a line item veto. recall not too long ago when the governor changed some of the appropriations bill to ensure that some educational funding extended for 400 years. Okay? And he can do that legally because he can strike out words and numbers and sentences in those appropriations bills. And again, I suspect that our great-great-great-great-great-grandchildren may benefit from that, but again, has the opportunity to do that as well. Likewise, our governor is the commander-in-chief of our state militia, and can also, like our executive president, can call the legislature into session for reasons that he feels are appropriate. That we've also seen in recent times. He does not have the capacity to direct that they do anything, but can indeed call them into session. You have seen them do that, seen this governor do that on several occasions, only to have the legislature quite literally convene and then adjourn promptly, right? When it does not want to do or act on the very subject matter that is the purpose of the calling into session. Again, our state governor, like all of the governors, has the capacity to pardon and grant reprieves. So, for example, the governor of the state of New York would have the capacity to pardon someone who is convicted in a New York court. The governor of Georgia would have the capacity to pardon someone who is convicted in Georgia. But once again, that's a state system, that's a state process. And you have to get...
The governor of Georgia doesn't have that power.
Pardon me?
I thought I heard that the governor of Georgia does not have that
It
power.
may well be. I think there may be some reprieve language, but it may not be quite the pardon language. So I may be appropriately corrected on that. But most governors do have language similar to this. The capacity to do some things out there. I know that Kathy Hochul in New York does have this kind of capacity. Not that she would, but just again know that those powers are completely unchecked when it comes even to state authorization to do those kinds of things. Once again, the authorization to administer and execute the work of state agencies created by the legislature. And again, like our federal constitution, which I did mention before, this other language here, that's the state of the state language that the governor is required to tell us how the state is doing. How are we doing? The condition of the state, and can recommend things for the legislature to act on. Our federal president can also do the same kind of thing. So again, you see these parallels between executive authority, federal and state as well.
Okay, I got the answer.
Yes.
Georgia is one of only 6 states in which a board operating independently of the governor makes pardon decisions. It's a secretive state board of pardons and paroles, but the governor appoints those members.
But again, there's a bit more process there, so your point is well taken. You get a little bit more of a check and balance. Not completely, but there's always some mechanism for doing this, right? But good to clarify that concept.
Could he shut down the investigation?
Could a governor shut down an investigation? The answer there is no, okay? Right?
Because technically, the way you're doing your numbers, right? Fannie Willis could be trying Trump if he was president while he was president.
Absolutely.
And the governor can't.
The governor cannot shut again because he is elected, but so is she. And she's got a different function, admittedly, not in the legislative area, not in the judicial area, but she's got a different function. The governor, he may declare something, but he's got no capacity to stop an investigation from going forward. That's why what you'll see again, I think it was more news just today, the former president's lawyers have been going into Georgia courts to try to get Fannie Willis off the case and also to have all these proceedings stopped. And the courts there, to their credit, are saying, no, this is ridiculous, it is frivolous, it's absurd. And so there is a great deal of independence by prosecutors. What can you do? If you don't like what they're doing, you can throw them out of office by electing somebody else, right? There's certain processes, again, depending upon the state, for impeachment, those kinds of things, but the governor does not have the capacity to tell a prosecutor what to do or what not to do, absolutely. So let's talk about 2 principal theories related to the power of, I'm going to focus principally upon our federal executive. That's Harry Truman, right? And there was a thing called the Korean, I describe it as the Korean War. It's technically the Korean conflict, right? Still to this day, not the focus of a particular peace treaty there on the Korean Peninsula, but nonetheless on the 38th parallel, right? And so in April of 1952, while there was a threat that the steelworkers in America across the industry would go on strike, the president decided, Harry Truman decided that would be contrary to our defense interests in South Korea. And so he instructed his Secretary of Commerce to go out there and nationalize the steel industry, make it all part of the federal government, okay? It's a little bit more complicated than that, but basically he wanted to make certain that nobody is striking, so the steel is still produced, and we can still produce, we can still advocate for and manage our war in Korea, right? And so his purpose may have been good as a part of his role as the commander-in-chief in charge of the military. The question is, and can a president do that kind of thing, right? Can the president enter what is basically an executive order directing one of his cabinet officers to nationalize some major industry for the purpose of supporting a war effort, okay? And so again, much more history here, but the United States Supreme Court gets a hold of this case called Youngstown versus Sawyer, and the doctrine is the Youngstown framework. As you go home tonight and think about this, and the court basically said, Harry Truman, what are you thinking? You can't do that. You can't do that. That's a legislative function. Only the people who are elected to Congress can do that. And you have got no express congressional authorization to do that kind of thing. You can't engage in that kind of behavior. Nor is there any basis for doing it, because a few years back, in connection with another labor dispute, the Taft-Hartley Act in 1947, after World War II, the Congress explicitly said that there will be no work stoppages or labor disputes in which the government would get involved. Okay, so Congress went in just the opposite direction. So we're not going to do this. And so the notion that here, Harry Truman, you can go out there as an executive and do this by virtue of executive order, can't do it. Only the legislature can do that. And there you see the principal language from the majority opinion in Youngstown versus Sawyer. Either the aggregate of the president's Article 2 powers, basically the notion that all the stuff that's in Article 2, kind of generally, this penumbra idea, that doesn't support this, nor, just because you're the commander-in-chief in charge of what's going on in Korea, does not give you this authority to engage in a legislative act. You can't do that. And because what you're doing is in the nature of lawmaking, what you have done or attempted to do is unconstitutional. Fascinating, right? And so that's in the middle of the Korean War in 1952 and 1953. Youngstown is decided, all right? And it remains to this day one of the fundamental concepts out there restricting the capacity of executives and presidents to act. Now, it's been applied in many, many circumstances, and you can well understand it based upon our discussion of Supreme Court cases out there, that sometimes you've got majority of the courts will say, well, Youngstown says you can't do that. Other times the Supreme Court will say, well, Youngstown was different. That was in the middle of a war. That was some other circumstance. It's not to say it's uniformly prohibiting presidents from doing this, but Youngstown is a fundamental principle that restricts the capacity of our president to act in ways that legislature should, right? And so in connection with that Youngstown case, this fellow, Robert Jackson, issues a concurring opinion. He's a lion, again, an icon in Supreme Court history. And he says, you know, there are three kinds, and this is also part of this Youngstown framework. He said there are three kinds of ways in which a president can act. First, the executive authority is at its height, unfettered capacity to act, when in fact, the Congress has expressly told you, you can do this. If Congress had passed legislation saying that, Mr. President, you can nationalize the steel industry, you go ahead and do it, because they've given you that authority. Or if they've somehow given you some other authority. We think a lot in the wake of September 11th about some of the war powers that were enacted. There you had a situation where they gave George Bush an awful lot of authority to act, and he used it, right? Probably not in violation of Youngstown or this framework, all right? And you can also do that, and it relies not only on the powers in section Article 2 of the Constitution, but all the others that the legislature may confer upon you statutorily. If they create agencies, the Department of Defense, Department of Commerce, Department of Labor, those kinds of things, if the Congress has given you that authority, and you've also got agencies out there, and you've got the authority by virtue of those things we've looked at before, you're pretty much certain that you can act in those areas, right? That makes sense. And that's the executive acting, executing the law that the Congress puts in place. And then Jackson says there's a second thing, and he refers to it as the zone of twilight. I often wonder whether that was the source for Rod Serling's show, right? He came up with it for Robert Jackson said it's a zone of twilight, right? And he said, well, in those cases where you're relying upon some independent authorities, right? That the things that are in the Constitution, but they may be also shared. There may be some responsibilities that are shared with the Congress. And here's the key to this second category. We've talked about this. Suppose that the Congress doesn't act, okay? Suppose there is inertia, as Jackson described. There's indifference. There's quiescence. Under those circumstances, for example, contemporary circumstances, situations involving immigration, right? The Congress has not acted in, 20, 30, 40 years. Guns, right? Many other things. Fixing Obamacare, which there's a fix out there to accomplish that. If there are circumstances where the Congress doesn't act, Jackson says, well, maybe that may enable or invite some conduct, okay? And so if the Congress is not doing its job, maybe you can act, but it's kind of in a twilight area, right? We're going to have a lot of litigation about it. We're going to fight about this probably. And it's always dependent upon, as Jackson says, love this phrase, the imperatives of events and contemporary imponderables. In other words, the things that are happening right now, there may be some circumstances, again, in the middle part of the 20th century that we can't contemplate. Maybe they'll give you the authority to do it, but just know that you're not quite on the ground that you would be in that first bullet point, where you've got express authorization. Here, you may have some shared responsibilities. Congress doesn't act, maybe you can act, but we're going to look very closely at that, right? And there's the third category, it's just downright, almost certainly unconstitutional. And that is where what you're doing is expressly prohibited by the Congress, and you decide to do it anyway. We're almost certainly going to find that's unconstitutional, again, because the legislature is the body that is responsible for giving you the authority to execute the laws that it passes. And we're going to give that some very high scrutiny. It makes sense right at that far end. You might think, well, gee, that doesn't tell me a whole lot about how to address all this, because once again, in applying this Youngstown framework, put together basically by Robert Jackson, courts can pick and choose, right? And we've seen in some of these Supreme Court cases that sometimes they will say, well, again, the Congress hasn't acted, or it has acted and has prohibited you from doing this. We've seen that in the cases that were just decided this past term. We'll get to at least a couple of those in just a few moments. What you should know tonight is this Youngstown doctrine is a very, very key element when it comes to understanding, key understanding of the responsibility of presidents and the limits of those responsibilities, depending upon whether they're expressly conferred by the Congress or not. If you've got express conferral, you're probably okay. If you don't, then you're going to have to argue it. It might be the circumstances permit you to do it, but if you're going to do something that's expressly prohibited, you're going to be in trouble, right? Makes some sense. That's Robert Jackson. And that remains good law to this day, and every so often you do indeed see invocations of this. I talk about the other theory that's sort of taken its place recently that also gives you some gloss on all of this. And so today, for example, just a few hours ago, our chief executive, presumably exercising authority under his role as commander-in-chief. He's also got capacity, as we know, to make treaties, to engage in other things involving foreign lands, to appoint and receive ambassadors. Earlier today, just a few hours ago, Joe Biden announced that we're going to give back to the Iranians a certain unclear number, maybe 5, maybe more, Iranians who are in our prisons. We're going to give them back to them in exchange for the return of 5 Americans, and we know who those people are. And they've been in prison for a long time. And oh, by the way, we're also going to free up about $6 billion for the Iranians to use monies for humanitarian purposes coming out of some oil revenues. Congress was not involved in any of that, right? Not at all. The president just came out, and plainly this has been in the works for a long period of time. Just happened this afternoon. Nobody, as far as I can tell, is saying, wait a minute, Mr. President, you had to get congressional authority to do all this. No doubt, there'll be great criticism, I'm sure it's out there right now, from the opposite party saying, oh my goodness, you're playing with the Iranians, we don't like those people, and you've given up our prerogative again down the road. Yes, you're returning some Americans, but look what you've done. You released criminals into the international sphere, and you've given them $6 billion. How could you possibly do that? It will be interesting to see what the response is, and whether anyone will say, this goes beyond your capacities as as our chief executive in the area of foreign affairs. Okay? Interesting, the Constitution does not say that the executive has plenary authority in the area of foreign affairs, international relations. It is assumed that he has the capacity to do this. As you know, the legislature is also, it's kind of one of those shared Jackson things. What does the legislature do? It's got the capacity to do what? Declare war, right? We don't do that an awful lot these days, but that also indicates Congress kind of has a shared responsibility there. In a perfect world, it would be interesting to see whether or not this kind of executive action would be subject to the Youngstown analysis. Does he have an express authorization to engage with the Iranians to do a prisoner swap? Prisoner swap language is not in the Constitution, right? And there's no specific legislation that says, yes, Mr. President, we want you to engage in this kind of activity to get these people back. But it certainly seems as the kind of thing that he would be able to do. There may be those debates in the coming days about whether or not this thing that happened just this afternoon, where does that fall inside the Youngstown analysis? Does he have the capacity to do it? I would certainly think he does. But just know that whenever that kind of thing happens, you kind of got to piecemeal together the position as the commander-in-chief, your treaty authority, which again suggests a foreign engagement, ambassadors, and kind of generally the notion that the chief executive is our person when it comes to representing us overseas. You also have legislators who do that. Hopefully Supreme Court justices aren't doing that. Maybe that's going to be next. We'll find out about that. But all of that pulled together from these various tendrils inside the Constitution to permit this to happen just this afternoon. Interesting, right? And so then let's talk about something else that happened in American history. That was today. Let's talk about something that happened about 140, 50 years ago. Article 1, Section 2 of the Constitution incorporates and codifies slavery in America, right? There's the language. The Constitution never talks about slaves, never talks about the color of skin, at least not in this portion. Later on we do talk about color. Does not talk about slaves in particular. But this is the portion of the Constitution, right up there, Section 2 of Article 1, that contemplates when it comes to representation in the Congress and when it comes to taxation, when we try to figure out how to tax the states and how to tax people in those states, we're also going to recognize that there are within certain states in our union 3/5 of a person, and those are slaves, right? And that's the language right there that codifies in our Constitution. This is the great compromise, it's right there, the notion that we are going to acknowledge and recognize horrifically that there are people in our communities who are not fully persons. There is the language right there. We know that after the Civil War, the Congress and the states rectified that. They removed that language. It's actually in the 14th Amendment, the second section. 3/5 is no longer in the Constitution. It's in the initial codification of this. In the 14th Amendment, that language goes away when it comes to deciding how representation and taxation is done. And there is the principal component of the 14th Amendment. And you can probably all recite it from memory. Everybody who's born here, naturalized here, you're all citizens of the United States, and the state where you may reside. Nobody, no state can make any law, enforcing the law that abridges the privileges and immunities of those citizens or deprive any person of life, liberty, or property, here we go, without due process of law. That's the due process of law language in the 14th Amendment. Or deny any person the equal protection of the laws. hugely important. That's the constitutional language that gives you due process of law and equal protection of the laws with respect to the states, right? The Fifth Amendment also has due process components to it, but until the 14th Amendment and before some other Supreme Court cases expanded that Fifth Amendment right, this now makes it clear that states also have to ensure that all citizens are entitled to due process and equal protection of the laws. That 14th Amendment, as you know, is 1868, all right? That's when the states ratified. Gosh, a time when the Congress would put together this and other post-Civil War amendments, and we get a majority of the states would ratify it, and that's a part of our Constitution today. But between that first language in 1789 and that second language in 1868, something else happened with respect to an executive in the United States of America. And you know what it is. It's this guy, okay? And what he did, and this is the reason why I passed this out as a part of your reading assignment, right? I think it's fascinating sometimes to go back to some initial documents, right? What he did was he said, well, and he says in 1862 in September, he tells you basically, hey, on January 1 of 1863, I'm going to free the slaves. He gives everybody notice, right, in that Emancipation Proclamation. That is a depiction of quite literally Abraham Lincoln signing the Emancipation Proclamation. And he also goes along to say, and by the way, I'm going to declare all these states in rebellion. You've got the list there. Talks about specific counties, right? Fascinating to read that, right? And he's got that much particularity. And says, I'm going to give you notice that come January 1 of 1863, I'm going to sign this document freeing all the slaves in America. And sure enough, he does it. And so he gives them notice in September. He does it on January 1 of 1863. Declares states in rebellion, right? The war is not over. And he frees the slaves. And he does something that I think is stunningly dramatic in the jurisprudence of our Constitution. Abraham Lincoln, to his wonderful credit, sits down with a quill pen, and with a stroke of a pen, he amends the Constitution of the United States of America with an executive order that says, you know what? All those 3/5 of people that are in the Constitution, passed by the states, that language no longer applies. They're all free now. And that happens before the 14th Amendment, which codifies what he did. But Abraham Lincoln does this after, while the first language is still pending, and unilaterally enters an executive order as our president, without congressional approval, not without some even internal dispute among some of his staff and other cabinet members. He unilaterally enters an executive order that changes the Constitution. Oh my. Did you ever think about the Emancipation Proclamation in that setting? We all think about it because, of course, it's wonderful, right? It's a great declaration about the humanity of all people, changes the geography of our nation. One has to wonder if Robert Jackson was around at the time of Abraham Lincoln, if he would say, well, wait a minute, you sat down on December 31st of 1862 and you put this fine document together and you signed it and you amended the Constitution in such a way that you freed slaves and changed that language so that when it comes to representation and taxes, this 3/5 concept no longer exists. Oh my, oh my. What a bold, stunning, wonderfully good thing for America he did. But it is an executive order without congressional legislation, without any approval of the states, and he sat down and he did it. And you have to wonder again, we can do this now academically, and I can be not flip about this very important thing in American history, but you can look at that and say, here we have a president who unilaterally, again, changed our Constitution with the stroke of a pen. And would that pass muster today if, name your president, were to sit down and issue an executive order doing something far less significant than changing who the citizens of the United States of America are? The Emancipation Proclamation was, to my mind, the ultimate executive order in our nation's history. And again, it is effectively ratified when in the wake of that, the Congress and the states pass the 14th Amendment and eliminates that language, and we've got that codified, so it's no longer an issue. But Abraham Lincoln did that as an exercise of his executive authority long before Robert Jackson came around and said, well, we're going to analyze this depending on whether it got your authorization. He just went ahead and did it. Fascinating in American history, right? Right? And so you wonder then about this other concept that's out there, and we have talked about this as well in the context of these cases that have been decided just in recent times. Specifically, you may recall, you do recall well, in one of our first classes, we talked about the decision of the United States Supreme Court to tell Joe Biden that he, through his education secretary, cannot implement a program that forgives student loans. $10,000 per individual, $20,000 for couples. You can't do that. The Supreme Court said that just a number of weeks ago. That is an executive order, basically, that you entered, Mr. President, that is unconstitutional. You can't do that. And what the Supreme Court said, again, principally through John Roberts, and another majority of the Supreme Court went along with this, is they invoke this major questions doctrine. We chatted about this a little previously. I'm going to revisit it because it's the other major concept out there that plainly now is affecting the capacity of our executive branch to act. And again, as Kristen observed in one of our early sessions, this is also not in the Constitution. The Jackson stuff, that's not in the Constitution. This isn't in the Constitution either, okay? But what the Supreme Court is saying these days is judicially created, maybe not out of whole cloth, but not out of any specific language in the Constitution, that if you do something, Mr. President, that's really big, colossal, for example, freeing slaves, and it's new, we've never seen that before either, we will not let you do that. Under this doctrine, the major questions doctrine, highly likely that if there had been lawyers running around loose as they are today, that people would have said, oh no, Mr. President, Abraham Lincoln, you cannot free the slaves. You're doing something, is it big? You bet it is. You're changing the Constitution. Is it huge with respect to citizens of the United States? Absolutely. Is it new? Of course it is. The founders of our nation never contemplated this would happen before, and it's in the language of the Constitution. Under the major questions doctrine, it says basically this, that unless the Congress has once again explicitly given you the authority to act, provided clear authority, and you're doing something with vast economic or political significance, freeing slaves, yeah, pretty much, right? You can't do it. If it's big and if it's new, you can't do it. And so that's the basis upon which John Roberts, again, a number of weeks ago said, with respect to the program to forgive debt, the Secretary of Education overstepped his bounds, the executive overstepped his bounds. This is too big, this is too new, and again, going back to Robert Jackson, only the legislature can do this. The legislature can pass laws like this, they can make those decisions, but you can't. That's lawmaking. That's what Jackson was talking about. But they described it again, not under the Youngstown framework, different kind of codification here. It's called major questions doctrine. It's not completely different, but different in a language and certainly different in the way it's being applied today. The other one that I always go back to again is during COVID. We talked about this before as well. The President's program to ensure that all businesses of more than 100 people have all of their employees either vaccinated or tested weekly. Okay? And exercise, again, taking care that the laws of the country be properly executed, probably so. All the other things that kind of are implicitly in this document under Article 2, also probably things we'd expect our President to do. The Department of Health and Human Services, right? Health, part of his commission from Congress. And he says, I'm doing this to keep us all healthy, or try to do that, to try to keep people from dying in America. And there's a challenge to that, once again, under the theory that he can't do that. Only the legislature can impose upon businesses this obligation to vaccinate all of its employees, get them tested, and absent that, the President can't do it, only the legislature can do that. And the Supreme Court says, again, with respect to the vaccination situation, the Supreme Court says, you're right. You're right. The President cannot do this. And so they eliminated, they invalidated, they found unconstitutional Joe Biden's attempt to ensure that companies with more than 100 employees were indeed vaccinating or testing all their employees under this theory. It's too big. It applies to all companies of more than 100 in the United States of America. Yeah, is that big? Sure it is. Is it new? At least in this century, we haven't seen this kind of a pandemic, right? So it's new, and this gets invoked to stop the present president from doing this kind of thing. Kristen.
So, first, just to be snarky, I can't wait to see people campaigning about all the small and old things they're gonna do when they get elected. But anyway, I mean, this is just dumb.
Yes.
But, so, do you think that, God forbid, something big and new happens to us, and the president does have to act
Right.
out of ethics and conscience, whatever? Is he just gonna do it anyway and wait for it to get through, and maybe that they'll change their minds, because they change their minds about things all the time anyway?
If you go back to the...
Is this really gonna stop anyone from doing it?
Exactly, right? The fact is, Joe Biden and Department of Justice and the people around his council, do they know about this document? Sure they did. They got beaten up a couple of times here recently, right? By this very doctrine, whether it's Jackson or this concept. The Chief Justice embraces and he loves this doctrine, okay? Do they know about it? Sure. Present your crisis for America. Probably the one that would pass muster is an invasion of a foreign country, okay? You're the commander-in-chief, you can call up the military, right? But things short of that. Let us suppose that you have, Maui is on fire tonight, right? You've got all kinds of other things. I realize there are congressional conveyances to FEMA and others that permit that to happen. But again, and that may not be new, but it certainly is big, right, in terms of things you have to do. Things related to water rights in the western part of our nation. Could be some civil unrest, civil rights issues. What do you do to ensure the tranquility of the nation? That language, once again, which I like so much about, to ensure that you take care that the laws are properly and dutifully executed. The take care clause provides you an awful lot of basis, at least linguistically and substantively, to act as the chief executive, to do what you think, exactly what you're describing, Kristen, to do what you think you've got to do to preserve the republic. Maybe it also involves, as Ecuador situations, if you've got situations where you've got, in the midst of a campaign, you've got people who are being assassinated, other things, all those kinds of things, you've got to act to ensure that the integrity of the process is ensured. And then you simply wait for somebody to run into court and say to a federal district court judge, you can't do this, right? And then you defend against it, and you come to the Supreme Court and you say, it may well be big and new, but I am consistent with what Robert Jackson said. These are the imponderables that he talked about, the future things that we can't possibly envision. I am acting pursuant to Youngstown principles, and really, members of the Supreme Court, you're telling me that I can't act, that there's something that's so critically important to the future of our nation, the livelihood, the lively nature of our nation, that you're going to tell me that the major questions doctrine prevents me from acting? Really, that would be fascinating. And yet, if Harry Truman were here today, he would tell you how angry he was when the Supreme Court came back and said, I've got to protect the future of our nation. We're at war in Korea, and I'm stopping the spread of communism, and I've got to do this to make certain the steel is flowing. And the Supreme Court told me I couldn't do that, and they did, and he stopped them. So we've got fascinating possibilities out there. Not just big and new, as you said, but also small and old, right? We'd like to think those would pass muster. We'll talk about one or two of those, but it's a fascinating concept, once again, please.
Well, I'm thinking about student debt and immigration. Aren't those like the Twilight Zone kind of things, where Congress isn't acting?
Absolutely. So you make that same argument. It's quiescent, right? That's the Jackson language. If Congress seemingly is disinterested, you invoke that language, and as the Solicitor General do, you put that in your brief and say, members of the Supreme Court, Jackson told me this is the situation. Yeah, we got some kind of shared responsibilities here, but when has the Congress acted on immigration, right? We haven't done it, right? And so I've got to act, and you make that argument. And the question is whether or not the Supreme Court would embrace the Jackson language or would continue to embrace what it said more recently, which is, well, when it comes to all these major issues along the southwest border, what you're doing, Mr. President, or Madam President one day, is just too big. And even though it may cause great harm to the Republic, the only thing greater than the harm to the Republic is our Constitution. And we can't let you do that because this document is sacrosanct. And that's what they would say. But you're absolutely right. And it leads to, of course, some other concerns that are out there, also in the news, right? Remember DACA? Remember DACA here also? Deferred action for childhood arrivals, right? There's a huge amount of history on this. It goes way back to 2014, right? When Barack Obama, actually introduced him before then, was attempting to address the situation of young people. Now, we've waited so long, some of them are in their 30s. I heard a report that a couple of them are in their 40s already. They're not exactly young, I'm sorry, 40s is very young. They're juveniles, right? They're always boys. But he was concerned, as you well know. You know what DACA is all about. We've got numbers of young, at that time, young people who are present in this country. They're brought here by their parents. And what do we do with them? What do we do with them? Plainly, we've got to find some pathway to citizenship. For what it's worth, there's the DREAM Act that gets reintroduced. It's different from DACA. DREAM actually does provide a very clear pathway, a legislative pathway to citizenship. That's out there. It gets introduced every single Congress. And again, if Congress were to act on that and not be quiescent, probably take care of a lot of this, right? Well, again, what does Barack Obama do? He says, and they're not acting. I've got to do something with this population of several 100,000 young people. And so along the way, it goes up and down again. We spent a huge amount of time talking about district courts and appeals courts. You may recall that along the way, in 2020, the Trump administration attempted to rescind DACA completely, right? And to basically put the final nails in the coffin of this thing. And interestingly, the Supreme Court, while not deciding on the merits of DACA, whether this is a good policy or not, said that the Trump administration failed to follow something called the Administrative Procedures Act. The way in which they tried to bring this to conclusion was not proper. And so they basically stopped Donald Trump, interestingly again, another president, from acting as he wanted to do. Why? Because he had not followed a legislative command about doing these kinds of things, even while they said, we're not deciding about DACA. Well, again, great deal of history. Joe Biden becomes president. First day in office, he says, okay, I've got to clean this up. He issues some new rules. Basically, some people have alleged it's Obama DACA with a very pretty bow on it. He does clean up some of the issues that are the subject of some of the decisions of the lower courts that found it problematic. And he reinstitutes the program. He says, we've got to take care of this. Needless to say, we go back into court on the Biden rules, and again, truncating a huge amount of litigation that's been going on. What happens is that as late as June 1, yes, this June 1, there's a district court judge, his name is that should be Andrew, not Andre, Andrew Hannon. He is, of course, in Texas, where they all seem to be, right? And he had previously already ruled, believe it or not, as these things go up and down, that the entire program is unconstitutional. It went up to the Fifth Circuit, which again is the appeals court in the South, Texas and the other two states just to its east. And the Fifth Circuit also said, yeah, we find that DACA is unconstitutional. It's an unconstitutional exercise of executive authority. But they remanded it back to the district court judge to address specifically the Biden-era rule, okay? And right now, that's where all of this is. It's pending in front of another district court judge in Texas to determine whether or not the Biden incarnation of DACA is legitimate. At some point, probably, this will go back up to the Fifth Circuit. They will probably also reaffirm their past view that this is unconstitutional. And it will probably make it back to, yes, the fill in the blank, the United States Supreme Court, which will have to determine, as it did not do before, whether this whole concept of an executive, whether it's Joe Biden or Donald Trump trying to rescind it, or Barack Obama trying to address this immigration issue. And the very things we talked about before, that's how you argue this, right? Well, Congress is quiescent. Congress is disinterested. It hasn't done this. I've got to act. What do we do with this population of hundreds of thousands of young people who have no place to be right now? and we've got no pathway forward to them, I'm acting, okay? And under Robert Jackson's theory, maybe you get acknowledging this is not an express authorization, it's not his first category, but maybe it's that middle twilight zone category that he talked about. You argue that. People will plainly come back, as they have already, and say, well, even this, DACA, is it big? Oh, sure it is. 600,000 people in America, that's not small. Is it new? Well, immigration policies are not new, but certainly the notion of an executive sitting down like Abraham Lincoln did and signing a document that says, you know what, I'm giving you a pathway to citizenship, whether it's a DREAM Act or as to DACA, basically giving them green cards, giving them the capacity to work here properly and legally. It's kind of big, right? So that has been the attack. The major questions doctrine also invoked when it comes to DACA. And we will see whether or not the United States Supreme Court, the lower courts probably will find it's still unconstitutional. But again, all these concepts being wrapped around on DACA, which is still, after all these many years, not resolved. An exercise of executive branch authority in the courts being challenged by people who say that the president has exceeded, in 2 cases now, his authority to act. And then there's this one, which I also gave you the article on. Actually not more complicated at all. You may recall well, again, the expiration of Title 42. Remember this past summer? This is the principle, the doctrine, if you will, invoked by the Trump administration to keep asylum seekers on the south side of the Mexico border during COVID. And the concept was that if you keep asylum seekers on that side of the border and do not permit them to enter into this nation, you will stop the further spread of COVID. Okay, remember this, Title 42? What happened was that by its own language, it expired in May. There was a case, believe it or not, in front of the Supreme Court about whether or not Title 42 and whether the Biden administration's attempt to rescind Title 42 before its normal expiration date was legitimate. It came and went. The Supreme Court said we're not going to decide this because it's all moot. So we don't get a Supreme Court case out of this, but we do get, interestingly, just a few weeks ago, in July, a district court judge in Northern California, for what it's worth, for those of you who are playing the home game here, John Tiger is an Obama appointee, okay? And John Tiger looks at the Biden rule that basically says, okay, we're going to rescind, Title 42 is gone, but in order to continue to try to provide some order along the southwest border, and there it is, look at how big it is, there's the southwest border. What we're going to do is, if you come into this country, and again, by the way, I should say that there is a tradition, both under regulations and the statutes, that if you are seeking asylum, the tradition of our statutes has been that you can enter our country, okay? It doesn't mean to say that you've got permission to have employment, that your presence here is sanctioned, but we will let you stay in America. Why? Because the country of your origin has plainly done something that has so scared you, arguably has victimized you, has beaten you, has done other things. Part of our largesse as being Statue of Liberty type stuff, right? Come to our nation, and while we're adjudicating whether or not you've got a proper claim for asylum here, we'll let you stay in this country. Donald Trump reversed that and said, no, you've got to stay on that side. Joe Biden says, no, we're going to go back to the way we did this before, but, in order for you to come here, what you need to do is you've got to get, basically, an appointment, okay? And this is, you get a lot of heat for this. He gave him there's an app that you can get, and you've got to talk to somebody to schedule something. You've got to at least initiate the process, is what Joe Biden's rule said. Okay, it's a little more complicated than that. And what happens is that also is challenged by various migrant groups who are advocating for their right to come into this country without that obligation to get an appointment or proving that you sought some legal protection back in the country of your origin. That's basically what the rule says. And so in July, just last month, John Tiger found that the new Biden rules are unconstitutional. That they do, in fact, as you saw in the article, they were not properly vetted, they were inconsistent with the Administrative Procedures Act, and beyond that, they're very similar. They're very similar to an earlier set of rules under the Trump era that he also found were inconsistent with the Constitution. And so what has happened here, as you saw in the articles that you read, is that the Tiger decision and the Department of Justice, representing the president, says, you're wrong about that. We still have the authority as the executive branch to establish some rules for the orderly entrance of asylum seekers into this nation. We're going to ask them to make an appointment, to fill out some initial paperwork and do that, okay? And so what has happened, of course, is this goes up to the Ninth Circuit. This is in California. And just last week, last Thursday, a week ago today, the Ninth Circuit said, all right, by 2-to-1 vote, and you saw this in the article, we're going to stay John Tiger's order. We're not going to make sure that it's not going to go into effect. And you can continue, Mr. President, to implement this immigration rule while we're deciding this, okay? In the meantime, what we're going to do is we're going to solicit briefs, we're going to do all the lawyer things, and we have oral argument about this. And at some point, the Ninth Circuit will decide whether or not the president's asylum principles and policies are constitutional. Again, it goes back to this basic issue. He is acting as if Congress were to pass these laws, you wouldn't have this issue, right? He is acting in a situation where you do have a significant problem here. As I said in this previous slide here, the apprehensions along the border have plummeted dramatically. Who knows? Maybe that's because of the rule, maybe not. We don't know for sure. We've got this statement by the Homeland Security just a day or so ago that we've already again indicate how strong the president is on immigration enforcement. We removed 85,000 individuals. This new rule is doing its work. We're identifying who should properly be here and who shouldn't be here properly. And oh, by the way, we're encouraging people who are seeking asylum here not to fall prey to those people who will victimize you, smugglers and other people who are offering benefits here that are not valid. And so once again, we've got a situation here where again the Ninth Circuit has said, we're to let you continue with this. We will tell you at some point soon whether or not this long-term immigration policy about the mechanism by which asylum seekers come into this country can be supported. And that's your present up-to-date, there's more to this. It's not showing up. All right. That is the end, if you will, of this exposition on executive branch authority. What the language here says, and again it got short for some reason, is next week we're going to be doing a portion on the rights and duties and responsibilities of citizenships. And to provide you with some positive things as we graduate all together, the language here, which I'll get to Kristen or to any of you if you'd like to take a look at it. We're also going to talk about something I promised in the last class, which is you've got lots of issues out there, right? Even tonight, kind of a mixed bag about what the president can and cannot do. The language isn't clear, some of the standards are unclear. What can you do to fix some of this? There are some remedies legislatively. I'm going to focus specifically on the Voting Rights Act. What can the Congress do to fix some of this? Even if the Supreme Court has said, Mr. President, you've overreached. What can the Congress do, or what can you do? What can even the executive branch do to address some of these problems in a time when there seems to be this problem with one branch of government not doing a lot of work, another branch of government doing a lot of work, but not always being successful in getting there. Last thing I will say about that, however, is we also know that the same Supreme Court this past term did permit, as you may recall from a case we talked about, did permit the Secretary of Homeland Security to make some decisions about the prioritization of deportations. So that's okay, because again, Congress has given you the authority to do that in that area. But these other areas, that's too much, that's too far. Next week, again, 2 weeks from now, we'll talk more about ways in which you can not get around that, but at least as citizens, you can advocate for change that maybe will begin to address and rebalance some of this